Hello, and welcome to this webinar, Protecting the Fair Housing Rights of People with Criminal Records, a National Reentry Week event with HUD. I'm Amanda Moore, Director of the Clearinghouse Community at the Sargent Shriver National Center on Poverty Law. Today's webinar is brought to you by the Shriver Center, a national leader in advancing justice and opportunity, and the Vera Institute of Justice, which makes justice systems fairer and more effective through research and innovation. Before we get into the webinar, I'd like to take care of a few housekeeping matters. We have had an unprecedented response to this webinar, with more than 2,400 people registering for the 1,000 spots that are available during the broadcast. In fact, we've had so many people register that we've encouraged people in the same offices to watch together to minimize the number of spots they're taking up. Because of this, we have a quick poll that we'd like you to answer, which we'll put up on the screen now. Basically, we would like to know how many people are watching the webinar where you are right now. So please go ahead and respond to the poll while I go over a few more logistics. So given this large response to the webinar, I expect that several of you have questions for the presenters today. We welcome those questions and invite you to submit them to us through the question panel in your GoToWebinar control panel. And I'll go ahead and answer a couple of questions now that always come up during our webinars. First, yes, this webinar will be recorded. We will send out a follow-up email within a few days to everyone who registered for the webinar. And that email will contain a link to a page where you'll find the webinar recording, a copy of the slides, and links to some additional resources. Second, today's webinar does not offer continuing legal education credit. Okay, so as for our poll, I'll give everyone another 5 seconds to answer that, and then we'll close the poll. Hopefully 5 seconds is enough time to count all the people in your room. Okay, well, let's close the poll, and we'll see how many groups you have watching. Okay, great. So quite a few of you did pile up together to watch this, and we really appreciate your efforts to minimize the number of spots you're taking up. So that allows us to maximize the number of people who are hearing this important information today. We know that some of you like to tweet during webinars and other events. If you plan to do so during today's webinar, we ask that you use the hashtag #ReentryHousing. This will help us follow the conversation, and we invite you to follow along. You'll also see on your screen the Twitter handles of the various participating organizations. There's at HUD.gov, at the Justice Department, with Department abbreviated DEPT, at NYCHA, which is NYCHA, at Shriver Center, and at Vera Institute. I'd now like to turn the presentation over to our moderator, Marie-Claire Tranley-Young. I have had the pleasure of working with Marie-Claire at the Shriver Center, where she's a staff attorney. Her work has focused on housing and criminal records, especially increasing the use of the Fair Housing Act to challenge unreasonable criminal records policies. This work arose from a Soros Justice Fellowship that she received in 2010. She most recently authored When Discretion Means Denial, a national perspective on criminal records in federally subsidized housing, which was released by the Shriver Center last year. A link to this report will be included on the website with the recording of this webinar. And Marie-Claire, I'll turn it over to you now.
We're happy to have you here today with us and to discuss this very important issue on reentry and housing. We can go ahead and today this webinar is brought to you by the Shriver Center on Poverty Law, which provides national leadership in advancing laws and policies that secure justice to improve the lives and opportunities of people living in poverty. We're also here co-hosted with the Vera Institute of Justice, which works with others who share their vision to tackle the most pressing injustices of the day. And they study problems that impede human dignity and justice and pilot solutions that are both transformative and achievable. So today we have a pretty jam-packed webinar, and we're going to have a lot of great information today. I wanted to just sort of start off with a general overview of what's going to happen. First, we're going to hear from Amy Solomon from the Department of Justice, who's going to give us an overview of National Reentry Week and how HUD's recent guidances fit into that general campaign. The second speaker that we have is Principal Deputy Assistant Secretary Lourdes Castro Ramirez, who oversees the Office of Public and Indian Housing at HUD, who will give us an overview of those guidances. She'll give us an overview and then sit down with me for a short question and answer session to talk about the guidance. Then we'll turn to examples from the field with Margaret Dzeriga from the Vera Institute of Justice, and then Dan Heffitz from the New York City Housing Authority will give us a perspective of their housing authority on how they've grappled with some of these issues. And the last section, we'll devote about half an hour to question and answer. We know there's a lot of people here today, and so we have a pretty wide array of panelists. We can go over them really quickly. I just want to make sure everyone sees the list of panelists so that as you hear things during the talks and you want to submit questions, that you know that there's people here to talk to you. So there's going to be 4 people from HUD, one from the Office of Public Housing Investment, a White House fellow, someone from Office of Field Operations, and someone from the Office of General Counsel. And I will give them much more proper introductions when we get to the Q&A section. We'll have 3 people here from NYCHA. I'm able to discuss different parts of their program. And Margaret and I, will also be available to answer questions. So with that, I think that we are going to turn to our first speaker, who is Amy Solomon from the Department of Justice. We're very lucky to have her here today. She's the Director of Policy at the Department of Justice's Office of Justice Programs. In that role, she provides policy guidance on issues including prisoner reentry, justice reform, and emerging initiatives focused on building trust between the justice system and communities of color. Amy established and chairs the Federal Interagency Reentry Council Working Group, spearheads policy improvements impacting public safety, housing, employment, education, veterans issues, and access to treatment, healthcare, and benefits. She works closely with senior officials across the administration on domestic policy initiatives, including Promise Zones, My Brother's Keeper, Pay for Success, and key components of the Ladders of Opportunity agenda. And prior to joining the department in 2010, she spent 10 years at the Urban Institute directing projects relating to prisoner reentry and public safety. We're very excited to have her here today to discuss the Department of Justice's work on reentry. Now to you, Amy.
Great. Thank you, Marie-Claire, for that nice introduction and for hosting this important webinar. I am especially pleased that it's being held today, as the Justice Department has designated this week as the first ever National Reentry Week. Today and throughout the week, agencies across the Obama administration are holding events to draw attention to the vital issue of prisoner reentry. We're celebrating the great strides we've made collectively to remove barriers to reentry so that people with criminal records who have served their time and paid their dues have the tools and opportunities to be successful, productive, contributing members of our society. In total, we're holding over 500 events nationwide, all promoting the importance of reentry. The photos that are about to scroll are from events held around the country this week, and they're just a tiny sampling of all that's going on. I had the privilege of attending our kickoff event this Monday in Philadelphia, where Attorney General Lynch and Secretary Castro announced new JRAP grants, which will support public housing authorities and legal aid partners to help young people clean up their records and gain a true second chance. Just before the announcement, the Attorney General and the Secretary met with men and women whose contact with the criminal justice system has stood in the way of jobs, housing, and more. One man had 2 misdemeanors that were a decade old, yet they hurt his job prospects and even his ability to go on a field trip with his kids. A young nursing student was doing well in school, but told that she could not perform her internship rotation at a hospital because of her record, which was actually inaccurate to begin with. Another gentleman had a conviction for car theft going back more than 30 years. That very old conviction, despite a clean record since, prevented him from working in long-term health care, the field he'd gone to school for. Their stories are a powerful reminder that even for those who have been on the right track for a long time, a criminal history can make it extremely difficult to turn the page and move on. But these individuals persevered. With the help of Community Legal Services of Philadelphia, they're all doing really well and even serve as role models for others. So this was definitely an inspiring event, but just one of hundreds. Every U.S. attorney is doing something this week for Reentry Week. Every federal prison, many state and local officials, second chance grantees, and nonprofits are participating, representing every one of the 50 states. For example, we've heard about more than 65 employment-related events where returning citizens have the opportunity to connect directly with employers and job search resources. There are over 75 resource fairs that will connect people to housing, legal aid, and other vital resources. Many fairs include pop-up centers to help people get a driver's license or an ID card, or learn about public benefits including Medicaid, Social Security, and help for veterans. We've also heard about 75 public education events, often by and for people who have been through reentry themselves. And more than 35 family events are taking place, providing children an important opportunity to engage and interact with their incarcerated parents. These are just a small snapshot of the activities underway. To see more and to post your own photos and stories, go to #ReentryWeek. We've also got websites listed at the end of the webinar for the National Reentry Week website at the Department of Justice and for the National Reentry Resource Center. All that said, our focus on reentry will not end this week. This issue is too big and too close to home for too many Americans. Many of you know the numbers by now. More than 600,000 people come out of state and federal prisons every year. More than 11 million people cycle through local jails. And more than 70 million people, some 1 in 3 U.S. adults, have a criminal record, whether arrest or conviction. Now the data is clear. Many arrests are for relatively minor, nonviolent offenses, and sometimes decades in the past. Yet many people remain locked out of opportunity over the long term. That's why our commitment goes far beyond Reentry Week. The Department of Justice and our federal partners, including HUD and some 20 other federal agencies, have been working together for more than 5 years through the Federal Interagency Reentry Council. We've been working both at the cabinet level and at the staff levels to open doors to employment, improve educational opportunities, and expand access to health care and housing, all in an effort to give returning citizens a fair shot at opportunity. HUD has been a critical partner in the Reentry Council, and you'll hear more about their efforts in just a moment. But other agencies have been key partners as well. For example, the Equal Employment Opportunity Commission issued guidance regarding the appropriate use of arrest and conviction records in employment decisions. This important guidance was issued in 2012 and helped pave the way for HUD's fair housing guidance today. The Small Business Administration expanded its microloan eligibility rules to allow those on probation and parole to apply. The Department of Justice directed all of its components to take collateral consequences into account when proposing any new regulation or guidance. And just today, HHS announced new Medicaid guidance that improves access to health care for the justice-involved population, particularly those living in halfway houses. Now, those are some of the policy changes we've made. In addition, the Department of Education has expanded their correctional ed and reentry programs that have been found to reduce recidivism, boost employment, and save taxpayer dollars. We're particularly excited about the Second Chance Pell pilot that will enable some incarcerated students to receive Pell grants to pursue post-secondary education and training. The Department of Veterans Affairs has developed what they call the Veterans Reentry Search Service, or VRSS, and this is a system that quickly and systematically identifies incarcerated veterans so that reentry planning and connection to VA services can begin early. And this system is already active in 218 jurisdictions in 28 states. Other agencies have created direct and centralized access to critical information that's often hard to find about Social Security benefits and child support modification, for example. They've created dedicated reentry web pages on existing federal websites that are easy to access and provide key information right from the source. And we're also trying to lead by example. This January, the Justice Department brought on board a first ever Second Chance Fellow, Daryl Atkinson, recognizing that many of those directly impacted by the justice system hold significant insight into reforming the system. This position was designed to bring in a person who's both a leader in the field and also a formerly incarcerated individual. Daryl now works as a close colleague to the Reentry Council and an advisor to BJA's Second Chance programs. He also serves as a conduit to the broader justice-involved population to ensure that the Reentry Council is hearing from all stakeholders. We're proud of these federal efforts and also so inspired by the state, local, and community partners who are leading the way with innovative and evidence-based approaches. While there's even more to do, by working together, we can make our communities even more safe, more fair, and more just. I thank you all for joining this webinar and look forward to hearing from Principal Deputy Assistant Secretary Lourdes Castro Ramirez and our other colleagues. Thank you, and back to you, Marie Claire.
Thank you, Amy, for that great presentation. The idea of looking for solutions that make our communities more safe, fair, and just, I think, is definitely something that we all are striving for, and so I appreciate your thoughts on that. That gives us a perfect segue to our next speaker, Principal Deputy Assistant Secretary Lourdes Castro Ramirez. As the head of HUD's Office of Public and Indian Housing, she leads a team of 1,300 professional employees nationwide and oversees and supports 4,000 public housing authorities and 566 Native American communities to provide safe and quality affordable housing and create opportunities for resident self-sufficiency and improved quality of life for 3.2 million households. Before coming to HUD, she previously worked at the San Antonio Housing Authority, where she served as president and CEO, and also the Housing Authority of the County of Los Angeles, where she was first the director of the Jobs Plus program and then the director of the Housing Choice Voucher program. We're excited to have her here today to share her insights with us. And here to give you an overview of HUD's reentry work is Principal Deputy Assistant Secretary Castro Ramirez.
Thank you so much. Good afternoon, everyone. Buenas tardes. I just wanted to clarify that I actually work for the city of Los Angeles, not the county. I just wanted to make sure that I clarify that because I think the city of LA would hopefully would follow up to make that correction. So it's wonderful to be with you all today. Thank you all for joining this webinar titled Protecting the Fair Housing Rights of People with Criminal Records. And my focus today will be to touch upon the importance of housing issues and addressing the importance of access to quality, affordable housing during this National Reentry Week. The fact that so many of you are participating with us today indicates just how important this issue is for all of our communities. I'd like to thank the Department of Justice, Amy Solomon, thank you for your presentation. Of course, to the Shriver Center and to the Vera Institute for hosting this event with us, and to Marie Claire from the Shriver Center for your kind introduction and for the leadership that you have provided on this issue. You've been a driving force, and we appreciate everything that you have done. President Obama has called America a nation of second chances, but to provide real second chances for individuals who have made mistakes and paid their debts to society, we believe that we have to focus on housing, because successful reentry into society starts with stable, quality, affordable housing. Each year, approximately 700,000 individuals are released from state and federal prisons. To put this into perspective, that's more than the entire population of the nation's capital. We know that more than half of those who are incarcerated are parents. It's also important for us to remember the children and the impact that this has on families. Upon release, these returning individuals are faced with rebuilding their lives, looking for a job, accessing essential services such as healthcare. But it's difficult for someone to get a job, to go back to school, or to turn their life around without access to safe and affordable housing. That's why we cannot talk about second chances or reduce recidivism without addressing housing needs. Just this Monday, I had the opportunity to participate in the Reentry Roundtable in New Orleans. And during the slideshow presentation, I actually caught one of the pictures that included the picture from my visit to New Orleans, where I had the opportunity to hear from residents, from the housing authority, as well as third-party property managers and a number of advocates. While they all brought different perspectives about the importance of reentry programs, and their perspectives, were at times at odds, they all had been working together towards one goal, and that was to develop a local policy that presented a second chance and a path to housing assistance for the members of their community. Now, HUD's role and effort has been very significant in this work. HUD has been a proud member of the Federal Reentry Council since its first convening. And 2 years ago, the Attorney General challenged every federal agency to address the consequences of being incarcerated or having a criminal record. Since then, I'm pleased to report that we have made significant progress. HUD supports nearly 4,000 public housing agencies that administer public housing and housing choice voucher programs across the country, each with its own unique admissions and continued occupancy policy and administrative plan. In response to the Attorney General's request, HUD first reviewed our regulations along with the policies of housing authorities and property owners. Our review found that many housing authorities, including Baltimore, Los Angeles, and New York City, are doing great work in this area by adopting policies that provide formerly incarcerated individuals the opportunity to live in federally subsidized housing. However, we also learned that there is still much work that needs to be done. We found instances where far too often individuals were being denied housing simply because of an arrest, even though no charges were ever filed. So we then issued guidance this last November to clarify for housing authorities and other federally assisted housing providers that under well-established law, an arrest cannot be used to provide prove criminal activity that would disqualify someone for HUD-assisted housing. Second, we saw cases where housing authorities and property owners would not rent to individuals with a criminal record or accommodate returning citizens upon their release, when there is, of course, great need in this area. So HUD issued additional guidance earlier this month, making clear to assisted housing providers nationwide, both public and private, that blanket bans against people with criminal records violates the Fair Housing Act when they proportionally deny housing to individuals. And third, we knew that young people who have been involved with the criminal justice system face barriers in accessing education, work, and housing, given the burden of a criminal record that could follow them forever. And as Amy Solomon mentioned earlier to all of us, this past Monday, Secretary Castro and Attorney General Lynch announced the Juvenile Reentry Assistance Program, also known as JRAP. This demonstration program will be providing assistance to 18 cities across the country. With $1.75 million in generous funding from our partners at the Department of Justice, JRAP will support partnerships between housing authorities and nonprofit legal service organizations. This funding will help public housing residents up to the age of 24 and individuals who would otherwise be able to live with a family member in public housing. Working with housing authority grantees and legal service providers will help thousands of youth across the country with expunging, sealing, and correcting their records. These efforts will go a long way toward improving reentry outcomes and giving people a real second chance. Finally, as mentioned by Amy earlier also, this work is not, just occurring this week. We are committed to continuing this work. In the course of the next month, we will also be releasing a practitioner's guide with reentry housing models from communities all across the country. We know that there is great interest in learning from what's working, and as a convener and as a facilitator, HUD plays a very important role. Thank you again to everyone for being part of this important conversation. And now I'll turn it over to you, Marie Claire, for some Q&As.
Oh, thank you. Thank you so much, Principal Deputy Assistant Secretary. That was a great overview of HUD's reentry-related work, and I thank you also for agreeing to sit down and answer some questions today. I thought maybe we could hone in on the two guidances that you mentioned. One is the arrest record guidance from November, and then the other is the fair housing guidance from earlier this month. Let's turn to the arrest record guidance first. As you already know or may know, in early 2015, we published a report called When Discretion Means Denial, and looked at hundreds of admissions policies from PHAs and other subsidized providers across the country. And in there, we highlighted the problem, as you mentioned, of housing providers using arrest as definitive proof of past criminal activity. So we were very encouraged by the November guidance that directly addressed this issue. Can you explain to us and to everyone in the audience, according to the guidance, whether PHAs can use arrest in any way in housing decisions?
Certainly. First of all, I just want to recognize, the excellent work that you did with the release of the document titled When Discretion Means Denial. I think the report was very well done and really raised, some very important points that call sort of attention to the importance of ensuring that our PHAs are aware of the discretion that they have, and also that we as a department do what we can to ensure consistency in applying regulations. So with regard to the question about whether arrest records can be used, to deny assistance, our notice, the notice that was published in November of 2015, followed up actually with a set of Q&As that were released just about a month ago to provide further clarification, points to the fact that an arrest itself does not prove that a person engaged in criminal activity should be or would be disqualified from being eligible for HUD-assisted housing. As we all know, there are numerous cases where arrests have been made that are inappropriate, and we also know that there are certain populations, Latinos, African Americans, certain populations that have a higher rate of arrest. And so an arrest alone should not be the only means for disqualifying an individual from housing assistance. For these reasons, our guidance makes clear that the fact of an arrest is not itself a permissible basis for denying someone HUD-assisted housing. But it's also really important to note that our guidance does not prohibit asking for or reviewing arrest records as part of the admissions process. We know that housing authorities and owners may continue to review arrest records, and if they see something that makes them want to actually know more or ask for further information, they have the discretion to be able to do that. As part of such an inquiry, a housing authority or owner may continue to obtain and review police reports, the disposition of any criminal charges, or any other evidence associated. But we wanted to make it clear that an arrest alone is not a disqualifier for housing assistance.
So for PHAs whose policies still permit them to use arrest as proof of criminal activity, how long is HUD giving them to change their policy?
Well, you know, all housing authorities must comply with existing regulations and the guidance that has been issued. And, you know, we have made every effort to ensure that all PHAs are aware of the notice. As I mentioned earlier, we issued Q&As to provide greater clarification. Our staff in the field also have received training and are available to provide technical assistance. But we do recognize that PHAs must engage in a public process to make changes to their administrative plan or to their occupancy plans. And we encourage them, if they are not in compliance, that we encourage them to initiate a public engagement process to make those changes to their policies. And, you know, of course, our staff is ready to assist with that process.
Great. I know that there are some constraints on your time, so there are a couple more questions about the arrest record guidance that I was hoping to cover, but I know that you have staff here that's going to be available to cover it. So I'm going to skip a couple of the questions that I have on arrest record guidance and maybe move towards the fair housing guidance. We have seen instances of PHAs using overbroad categories of criminal activity. So, for instance, denying anybody with a felony conviction. And in fact, it's a lot of people have that misconception that you can deny somebody with a felony conviction. Can you explain to us under the fair housing guidance basically what the guidance is really all about? I think there's some out there who have maybe preconceived notions of what the guidance says, but if you could explain to us who does it apply to and whether this is really a change in the law, I think that would be really helpful for people.
Yeah, certainly. And so what I will do is, you know, provide sort of a general response, but I know that during the webinar, we have another panel that includes a member from our Office of General Counsel who is, you know, very involved in this process and will, you know, answer more questions, or more technical questions. But, you know, just generally, the Fair Housing Act it was a law that was passed in 1968, which prohibits both intentional housing discrimination and housing practices that have the effect of this, you know, discrimination because of race, religion, sex, disability, familial status, or national origin. So essentially a housing provider that violates the Fair Housing Act when the provider's policy results in a discriminatory effect is, so, you know, the guidance speaks to the fact that if their policy results in unjustified discriminatory effect, that needs to be rectified. That even if there is not the intention, that a housing authority needs to be aware of the impact that is having. What our guidance basically says is that the criminal background screening policy that has a disparate impact on people, particularly, you know, individuals because of their race or national origin, that if their policy violates the Fair Housing Act, if it's either if there's no legitimate, substantial, non-discriminatory purpose, or where the policy has a legitimate purpose, there's a less discriminatory alternative that would achieve the same purpose. So essentially the Fair Housing Act protects individuals that are discriminated against without even having sort of the intention, if it's resulting in a disparate impact. And again, our Office of General Counsel is available to go into more specifics on this. HUD guidance essentially builds on the Obama administration's comprehensive efforts to ensure that people with criminal records, that they can effectively re-enter their communities to become productive members of their communities. And ultimately, I think what we're striving for is to reduce recidivism and support families and communities and give people a second chance.
So the November guidance was issued by Office of Public and Indian Housing, so that applies to just PHAs. The Fair Housing Guidance applies to all housing providers covered by the Fair Housing Act. I was wondering, from your point of view as the head of public housing, what are some of the ways in which PHAs might have to revisit their policies because of the housing guidance?
Yeah, so let me just clarify, Marie-Claire, that the November guidance actually applies to not just public housing agencies, but it also applies for properties that are under any federally assisted housing program. So what we normally refer to as our multifamily program. So this extends beyond public housing. And you are correct, the second notice on fair housing extends to private owners, so it covers everyone. With regard to the effort that HUD is making to raise awareness and to ensure compliance, as I mentioned earlier, we've issued guidance to PHAs. We've issued additional Q&As. Our staff have gone through training and are available to assist public housing agencies that are looking to revise their policies because they may be out of compliance. We're also putting together a guidebook that really draws on the great work that is taking place across many communities. When I was in New Orleans last week and sat down with residents, the housing authority, and advocates, and really to understand the policy that they have put forth, I realized that these are at times difficult conversations that communities are having, but they are necessary conversations. And our role at HUD is to facilitate, to convene, and to ensure that there is good communication that's coming from the department and good guidance to support communities that are focused on ensuring that individuals, whether they be adults or youth, that are coming back into their communities are able to reintegrate, are able to get back on their feet, and are able to reach their potential. So we're committed to this work. We appreciate the partnership that we have with the Department of Justice, and we very much appreciate the partnership that we have established through the Reentry Council to the Shriver Center and to the Vera Institute of Justice.
Okay, well, thank you very much. I did want to note that we do have members of Stand with Dignity from New Orleans in the audience, and they wanted to thank you for your leadership and listening to those most impacted by the issues and who have been fighting for first-class citizenship in this country. So, thank you very much today for spending time with us, and I'm sure there's lots of other questions. So if people have questions, you can submit them, and we will have HUD staff at the end to answer more detailed questions. But thank you again for your time, Principal, Deputy Assistant Secretary.
Thank you very much. I just wanted to note, Marie-Claire, that today is Bring Your Child to Work Day, and we've had a lot of young kids here at our office, and so earlier, is he still here? We have Cameron. We had a 8-year-old, maybe? 7-year-old with us listening into this conversation, so it's never too early to start.
That's wonderful and very well behaved. I have not heard a peep.
Yes. All right, thank you all.
Well, thank you so much. So we will move on now to discuss some examples from the field after we had heard HUD talk about some of the ways that people, that housing providers might be able to increase opportunities for people with criminal records. So I'm going to send the webinar to Margaret Zerga, who's been a great person to work with from the Vera Institute. Margaret works on a wide range of projects related to family contact and families' roles in reentry for adults and youth in correctional settings. Most recently, she's been working on public housing access for people with conviction records, including developing the Family Reentry Pilot Program with the New York City Housing Authority, who we will also hear from later today. And before she started at Vera in 2009, she was the Director of Training and Technical Assistance at Family Justice. So you can take over now, Margaret.
Great. Thank you, Marie-Claire. And thank you all so much for sticking with it, even though the Principal Deputy Assistant Secretary has concluded her remarks. We really appreciate the interest in the webinar. So if we could advance the next slide, please. So building on the federal focus on reentry, there are a lot of innovative things happening at the local level. These innovations are happening in dozens of communities across the country, ranging from Los Angeles, California, and Akron, Ohio, to New Orleans and New York City, which have been alluded to earlier. And this afternoon, I'd like to focus on 3 areas where we're seeing reform. The first is on Public Housing Authority admissions policies that govern who can apply for housing, as well as who can apply to join or rejoin an existing household. The second is on reentry programs that help people immediately upon release from prison, jail, or juvenile facility to access public housing or Section 8 vouchers. And the third area is around city ordinances, which can create more consistency in how criminal background checks are used in housing applications. So if you could please advance the next slide. So we have our pals from STAND on the line. Hi, Colette. And I think it's really fitting to start with the work that's been done in New Orleans around modifying standards of admission. So the HANO policy was approved in March of this year. And the work was really led by resident advocates in New Orleans in partnership with legal service providers, law enforcement, property managers, and many others. And we at Vera really enjoyed working closely with all the stakeholders to develop this policy. And I think one of the things that really stands out and sort of the key takeaway is that HANO specified the convictions that are of concern to safe and stable housing. They described the time frame since the conviction occurred or the release from a correctional setting, whichever was more recent. And they created a very clear process that allows for an individualized assessment for people with convictions of concern. So the big change here is no one is automatically denied, aside, of course, from the federally mandated exclusions. And I just want to take a moment to read this language that's directly from the policy, because I do think it connotes a shift in how we're thinking as a country about access to public housing. So the HANO policy states, there is absolutely no presumption that an applicant with a criminal conviction should be denied housing assistance. Before making a decision to admit or deny applicants with criminal convictions, they shall be given an individualized review based on accurate information, including notice and opportunity to be heard. Individual circumstances and the potential impact on safety of other residents should be taken into account in the decisions as outlined below in the policy. And I certainly welcome you all to read it in more detail and look at the kind of the ways that the individual assessment is described, the ways that convictions of concern are detailed, as well as the time frames. If we could go to the next slide, please. So on the topic of admissions policy, it's also important that the admissions policies are detailed such that residents and prospective residents are clear about when people with convictions are eligible to apply. You know, as we heard earlier, the Shriver Center and Marie-Claire really did an incredible job of synthesizing tons of ACOPs, or the admissions and continued occupancy plans, housing authorities across the country. And in their report, they found a policy in Richmond, Virginia that's particularly detailed in describing when applicants with conviction histories are eligible for housing. They have various tables that really breaks it down by conviction. It encourages you to look at, is it the number of felonies over this time frame? It's just very clear and clearly designed for people who are seeking housing to know when they're going to be eligible to apply. I encourage you to read through the report and discuss with your colleagues whether there are ways that your policies could be similarly clear if they aren't already. And the report can also give you insights into how your policies compare with adjacent jurisdictions and may open up discussions about how city and county housing authorities, who may well have different policies, can increase consistency and clarity for residents in their area. In looking at your own policies, there are sort of several types of revisions you may want to consider. Thinking about consistency across third-party property managers, if your city or county has multiple different management companies it's working with. Taking a look at the look-back periods and really thinking about what we know from the social science and other things about what makes sense for those look-back periods. Examining the types of convictions that may prohibit access to public housing and think about which ones are really connected to public safety. And then we've talked a little bit about the individualized review of all applicants. But one thing that came up in a lot of the discussions in New Orleans that I really learned from my colleagues down there is that, being mindful of the quality of the background reports that you're getting and the kind of companies that are providing them and really understanding what's behind those is also an important step. So if we could go to the next slide, please. So we've talked some about admissions policies. Now let's focus on family reunification programs. The Los Angeles pilot program is designed to help get people added to their family Section 8 voucher. The family must then work with the landlord to accept the voucher that includes the recently released family member. And the Housing Authority of the City of Los Angeles is partnering with a couple of nonprofit partners, including a New Way of Life, which you may have heard of. Similarly, in Chicago and Cook County, their pilot program allows people to rejoin a family or to get their own apartment. The participating service providers grant what they call a reentry certificate to clients, which they can use as proof of mitigating circumstances in their applications for housing. And the photo I borrowed from the Chicago program is of a woman holding her keys and celebrating her return home. If we could go to the next slide, please. So the third type of reform that we're seeing is around ban-the-box efforts. And you may have heard about these in employment and other settings, but we're seeing a couple of places that are modeling those kinds of ban-the-box efforts to remove inquiries about criminal convictions in housing applications. So there's an ordinance in San Francisco and in Newark, New Jersey that I encourage you to take a look at. The San Francisco ordinance requires that affordable housing providers must conduct individual assessments of each applicant with a conviction history rather than automatically denying his or her application. The assessment must consider directly related convictions only, time since conviction, and evidence of rehabilitation. So again, another effort to try to create a more consistent approach to providing housing access for people with conviction histories. If we could go to the next slide, please. So for all the great work I've been referencing, to me, one theme is really clear. This work requires partnerships. This diagram highlights the range of potential organizations in your community that have a shared interest in public safety. In larger cities, you may have this full set of partners ready to dive in and see what might be possible. And I'm sure there are many that you don't even see here that pop to mind. In smaller communities, it may be the Housing Authority and the Reentry Court or the parole office who start working together. No matter where your conversation begins, you may be surprised how many people in your community you end up engaging in this important dialogue around access to housing for people with conviction histories. You're going to hear next from the New York City Housing Authority, or NYCHA, on their efforts to bring stakeholders, not unlike the ones on this slide, together to talk about issues around public safety and safe reentry. If we could go to the next slide, please. So it is my pleasure to introduce to you Dan Hayfitz. He's a senior advisor to the General Counsel at NYCHA, and he's going to share with you some more information about the work that NYCHA has been doing over the past several years, and I will turn it now to Dan.
Thank you, Margaret. Thanks, and good afternoon, everybody. I want to thank the Shriver Center, Marie Claire, and our host for the opportunity to speak today. And I just want to say on behalf of NYCHA how excited we are for this moment, this national moment on reentry. It's been an exciting time across many areas, employment, criminal justice, but we think especially in housing. And I want to take a moment also to acknowledge the really important work HUD has done in a number of critical areas, though I would like to highlight the recent guidance, which we think provides a critical framework for housing authorities to make good, smart, and better decisions as it relates to public safety, and also provides a platform for assessing existing policy and practice. I'm going to talk, next slide, please. I'm going to talk specifically about NYCHA's Family Reentry Pilot. Next slide, please. Thank you. I'm going to talk specifically about NYCHA's Family Reentry Pilot, and going to try to connect it to some of the broader themes that we've been talking about today. So I think that, first and foremost, what our Family Reentry Pilot does is it reunifies families, and this is something that is just a good in of itself. And it provides a basis for promoting stable housing, again, which is something that is just a good in itself, but also has practical benefits by helping to reduce homelessness and reduce recidivism. And we think that this is kind of a critical point to break the vicious cycle between homelessness and recidivism that the Shriver Center and others, Vera and others have really highlighted. The Family Reentry Pilot also gives NYCHA an opportunity to align its policy and practice with broader New York City criminal justice reform, and not just the city, but the state and the federal government as well. Next slide, please. Our jumping off point for the Family Reentry Pilot was the 2012 letter from then HUD Secretary Sean Donovan calling on public housing authorities to assist in helping ex-offenders reenter. It caused us to look at what NYCHA was already doing on reentry, and consistent with HUD guidance and along the lines of what Margaret has described, Hano's recent changes, and we look at key factors. So, and this is anytime someone is applying for admission or to be added to a lease. We analyze the crime committed, the nature, the seriousness of the crime, how recent the crime was, which we understand from criminology, social science is a critical factor, and then mitigating evidence. And the mitigating evidence, I think, is really important. It's the kind of evidence that will help us examine whether or not the risk that someone poses based on the other factors, the kind of evidence that will suggest that there is enough social structure or structures to kind of mitigate that risk. So NYCHA was making some other administrative changes around this time relating to look-back periods. We can go into that in more detail in Q&A if you're interested, but I think the upshot is that it allowed people to re-enter sooner and made them more likely to actually be admitted. So kind of taking a step back at what we were already doing, we arrived at this pilot, which addresses kind of the critical post-release period, which you can kind of call the high-risk, high-need period right after release, when someone may not have an established track record already demonstrating that they've turned their lives around, but they have the desire, they have the motivation, and really they need housing as the next critical piece. Next slide, please. So that's exactly where this, advance the slide, please. That's where the Family Reentry Pilot comes in. It was designed as a 2-year pilot. We extended it for an additional year. It's for individuals aged 16 or older who are leaving prison or jail, and it reunites them with their families who are living in public housing. It's a collaborative effort between the New York City Housing Authority and the New York City Department of Homeless Services, the Vera Institute of Justice, Corporation for Supportive Housing, who I just want to stop and take a moment to acknowledge and really highlight their participation and their role, which has been absolutely critical for NYCHA in getting this off the ground, developing it, planning it, running it, assessing it. They've been really the best partners. And then our other partners who provide case management services who are kind of perform a critical piece. So I think initially there was concern that NYCHA would just be letting in all the criminals. And so we designed a pilot that would kind of address the risks and concerns. And I think what we found initially was that there was actually a big appetite from our tenants for a program like this, that they wanted, that they welcomed the opportunity to bring family members who were reentering back in. So the pilot, there's some operational details on the slide. The pilot basically, it's structured as with an internal and external role. So externally, the case management providers, they identify participants who are motivated, who want to join, they assist them on the application, and then if they're admitted to the program, they then provide case services for 6 months, the first 6 months, and then additional services as needed. NYCHA then, on the internal side, NYCHA takes the application. We do a criminal background check. We review, the application gets reviewed by a screening panel. Our family services department does outreach to the family to make sure that they're good candidates, people who are going to be supportive of the reentering individual. Next slide, please. So I can't emphasize enough, I think Margaret has emphasized this, that partnership is the key ingredient. We are at, these individuals are entering at this high-risk juncture, and so the Housing Authority feels that we need a confidence factor on these individuals. And I think that comes from the fact that they're getting the support structure from the provider community. So these providers, they are experienced, they're trusted, and they're going to help people get them on the right path. We've highlighted a few of the other, there are a dozen or so reentry service providers in the community, Vera, CSH, partners in city government, which I think if you take a look, it really highlights the connection between homelessness and criminal justice. We have Department of Corrections Probation and the Department of Homeless Services, and then obviously also our state partners. Next slide, please. So just kind of talk about some of the lessons learned and the significance, and I think we really have to start with the human factor here, which can't be overstated. For individuals who are reentering public housing, some who have been incarcerated for decades, I think the power of being able to reunify with your family is significant. There are a number of individuals in our reentry program who are in their mid-40s and are now, through the program, living with an ailing or ill mother and are the primary caregivers. And I think the psychic power of being able to reenter and kind of claim this role in your family is really empowering, and we think that it plays a really important role. So, I mean, just to state the obvious, housing is a critical role in helping someone who's reentering kind of make an impact on their lives. For us, I think the message is, it's safety, right? There is a way that you can do this. You can be concerned about safety, and you can be concerned about families. And we feel, very confident about this. This is not, I think moving away from the concept or the association that some people have that housing authorities are trying to punish or they're trying to do moral policing. I think we look at, criminal backgrounds because it is essential to our mission to promote the safety of our residents. But there, I think that with the guidance from HUD, which is a core focus on individualized assessment, risk, safety analysis, kind of guiding us on the relevant factors, we think we can really get to a good place for reentering families. Alignment, which is really when we talk about the systems integration, that's essential. And I think this idea of a unison of movement, where is mutually reinforcing benefits that come when government agencies work together. And I don't just mean across the city, but also different levels of government. So I think taken together, the pilot, the work that other PHAs are doing, what HUD is doing, really signals a new direction nationally. NYCHA is very happy to be a part of this and be a part of the conversation. There's some other work that we're doing. We recently received a JRAP award, which has been discussed today. And we're also doing a very deep dive review of our occupancy and tenancy procedures right now to make sure that it lines up with the best that the research really has to offer. And I think with that, if we just advance the next slide, we can just leave it there for a second and just we'll show some of the outcomes that we've seen through our pilot, our reentry pilot, and we're more than happy through Q&A to kind of go through some of the numbers just at a high level here, but happy to expand some more. Thank you.
For that overview of your program, Dan. So we've hit the section of our webinar today where we're going to discuss, or we're going to have Q&A. There's quite a few questions already, but I still invite people to submit questions. All the questions that will be given today will be given to HUD and NYCHA and all the participants. And so if your question isn't specifically addressed today, it will be on everyone's radar and hopefully addressed. So I'm going to go ahead and go through, Amanda, if we could have the question and answer slide up, if it's not already up, that would be great. I'm going to go through the panelists, and amongst all of these people, we'll have maybe some answer or somebody who can search for an answer for questions. First, we have 4 people here from HUD. The first person is Ron Ashford. He is the Director of Public Housing Supportive Services in the Office of Public Housing Investments. We also have Ray Onishi, who is a White House Fellow at HUD this year. We have Joanne Wallington, the Director of Coordination and Compliance out of HUD Office of Field Operations. And finally, we have Casey Weissman-Vermeulen, who is a trial attorney in the Fair Housing Enforcement Division in the Office of General Counsel. So amongst those 4, there can be, should be able to address issues related to JRAP, the arrest record guidance, the fair housing guidance, and enforcement of those guidances. From NYCHA, we have Dan. In addition to Dan, we have Yolanda Johnson-Petterkin, who is the Director of the Family Reentry Pilot Program that Margaret and Dan discussed, as well as Melissa Quirk, who is a Special Assistant for Federal Policy and Legislative Affairs at NYCHA. And Margaret and myself will also be available for questions if you have any specific questions for us. So because we just had Dan talk, I thought maybe I could have a smooth transition and ask him a question, or NYCHA in general. Maybe this is a question for Yolanda as well. There was a question from the audience as to how many people have actually been accepted into the pilot and what have been the challenges in implementation.
Thank you. We have currently 66 individuals who have successfully been accepted into the program. This is Yolanda.
Have you had any? Thanks, Yolanda. Have you encountered any challenges in implementation of the program that you would like to share?
Well, we have found that helping individuals be able to make sure that they are connected through the process. So it is somewhat of an application process that they do through the providers. And sometimes they'll try to contact us directly and try to find out if they can move in. But, you know, we've worked through some of our implementation processes. And since it's a pilot, we have an opportunity to take a look at some of our application processes. But so far, it's been going pretty well.
Okay, great. The next question I have is geared to the HUD group, probably Casey, though others may weigh in. The question is, so speakers have reiterated that mitigating evidence should be considered by housing providers in evaluating a criminal record. The question is whether there's any guidance on what constitutes mitigating evidence, and this person doesn't specify between public housing authorities or federally assisted housing or private. So I'm just going to assume that it's a general question. So the question is whether there's any guidance on what constitutes mitigating evidence, or whether mitigating evidence is similar to the reasonableness standard of a reasonable accommodation. In other words, is it something to be evaluated on a case-by-case basis using judgment and common sense?
Well, it's certainly something, I mean, the disparate impact standard generally applies on a case-by-case basis. And, you know, how a disparate impact analysis plays out will always vary depending on the particular screening policy that you're looking at. But in terms of mitigating factors, the guidance does discuss some of the, you know, things that housing providers can consider when reviewing an application of a person that has a criminal record. And some of those things include like the facts or circumstances surrounding the criminal conduct, any efforts at rehabilitation or participation in rehabilitation programs by the individual, how old the individual was at the time the criminal record or criminal conduct occurred, what's the age of the person when they apply for housing, and you know, one that should be a no-brainer for housing providers, but recent tenant history. So, you know, it's very possible that somebody has a criminal record, but they've been out, you know, they've served their time and they've been out in the world for, you know, decades. And really recent tenant history would be more relevant in that circumstance than their criminal record. So some of those things are in the guidance that HUD issued back in earlier this month.
So, and if housing providers, oh, go ahead, Brown.
No, go on.
Oh, I was just going to say, and you should feel free to jump in when I'm done. If people are looking, if housing providers are looking for examples of what other housing providers are using in terms of mitigating evidence, we do have a section in that trying to pick out some of the better policies in the Shriver Center report, which we will include as part of the email that goes out the link following the webinar. Go ahead, Ron.
Great. And I would like to, if you don't mind, go back to the NYCHA pilot, because I know that there are more than 1,000 people on this webinar today. And this is Ron Ashford, by the way. And I wanted to say that the NYCHA pilot and most pilots that housing authorities are engaged in happen because third parties came to the housing authority. So it's not like NYCHA said, well, let's do this program, but it was Vera and other organizations who came together, who devised a program that had as a key component case management, went to the housing authority thought about it and said, okay, let's try it. That can be done in other cities, but what it takes is a group of, and there was a diagram up there, a group of organizations coming together, including a group that's willing to do the case management, having a meeting with the executive director, and sitting down and trying to get to yes. Vera and myself and another group here went to the DC Housing Authority, and we did exactly that, and the executive director took a breath and said, okay, let's try it. So I would really urge and encourage organizations, and there might be 5 organizations, and I'm making this up, in San Francisco who are on the call, coming together and saying, okay, can we develop a program that has these safeguards, if you will, and go to the housing authority and make a presentation. We can't make the housing authority do that, but we can open the door if you need to have the door open to a meeting with the housing authority executive director. Thank you.
Thanks, Ron. We appreciate that. This is Yolanda at the pilot program, and you're 100% right. I truly believe that when you try to start a pilot such as this, or you want to move towards trying to open opportunities for people who have criminal justice history to move back into public housing authority, you need a lot of help. So you're going to need somebody from those communities. You're going to need somebody to help you be that catalyst through. But it is certainly doable if you have the guidelines and the climate of HUD assisting you right now. It is certainly an opportunity that you will have to be able to get those safeguard programs and get them started. And we in New York at NYCHA will fully support and help you along the way.
Like that.
Thank you, Yolanda. I think that the pilot programs have been really great for helping people, especially who have been recently released. I think in addition to that, though, I think also the fair housing guidance will be very helpful towards making sure that the policies that keep people out of housing also help the people who have been out for a long time and may have already resettled their lives and developed support, have a job and are able to support their families, but are just being discriminated against on behalf of or because of their criminal background check. So the great thing about that we tried to organize at this webinar today was to address all of those populations when we use the label people with criminal records. So I have another question. This is kind of a simple question, but one that's been coming up for the notices from November. There's a question on whether the criminal background guidance applies to housing funded under the Native American Housing Assistance and Self-Determination Act. So I think those cover the Native American communities under PIH. There's also a question of whether it covers USDA and low-income housing tax credit properties. So I think someone from HUD can take that question.
Someone from HUD will take the question and say, I'm not sure. I would imagine that it does cover Office of Native American programs, but I can do a double check on that. And then the other question is whether it applies to USDA, U.S. Department of Agricultural Housing. Am I right?
Mm-hmm. Yes.
That housing, our notice applies to HUD, so I don't think that we can answer whether it applies to USDA, but again, these are two questions that we can explore further and then get back to the Shriver Center, and Shriver Center, you can get those questions out to everyone. It's fair?
Okay. Yeah, great, thank you. I have another question for HUD. And it is regarding, again, the arrest record guidance. I think in the arrest record guidance and also the FAQ that came out earlier this month in explaining that PHAs could not use, I'm sorry, I should say, I think this question might go towards Joanne, if we do have Joanne here today. Joanne, are you here with us today?
I'm here.
Oh, okay, great. I just wanted to make sure. So the question is regarding the use of police reports. So we know that housing authorities are not supposed to rely on mere arrests to deny people housing in admissions, terminations, or evictions. The notice and the FAQ refers to police reports. Some may say that police reports are not totally reliable, and so what is HUD's stance on these types of evidence to prove criminal activity?
Sure, thanks. That's a really good question, and we've received a lot of questions about police reports in general. Our goal is to not necessarily tell PHAs what they can't use, but tell them what they can use. So in this case, police reports would be one of several different types of evidence they could use to determine whether there was actually disqualifying criminal activity.
Okay, so it's a type of evidence, but it could be, depending on the case, it could be reliable or unreliable.
Right. So if it would be up to the applicant, the person that is applying, or the participant, if it's disqualifying their assistance, to be able to show that that was unreliable. I'm not sure a PHA would be in a position to know if the police report was prove to be reliable or not.
Okay, so basically, so it's something that's possible to use, but it's not a green light to deny on any and all police reports. Is probably a fair statement.
Right. I think it should be a starting point that, or a part of a larger inquiry, but not the only thing. Similar to the arrest records, it shouldn't be the only thing, but can be one thing.
Okay, I think that's really helpful for a lot of people. There are a number of questions about that. And the next question I have is for NYCHA regarding the pilot again. The question is, what impact has the NYCHA policy had on lease compliance for new families, for new admissions, with your pilot families over the first 2 years of their tenancy and beyond?
So the question is, what effect does it have on lease compliance? The pilot fits neatly into our lease provisions. It is essentially, it's piggybacking on temporary admission, which is a standard procedure, and so it really just slots into that. There is no impact.
Okay. Thank you, Dan. We have another question. Well, I guess one general question is regarding the fair housing guidance and what steps HUD may be planning to take to implement that guidance further. I think there's also a question of whether there will be further information for privately funded housing. So not housing within the federally subsidized programs, but landlords, private landlords who fall under the fair housing guidance.
Well,
that may be directed towards Casey.
Yeah, I mean, just to be clear, the fair housing guidance applies to all housing providers covered by the Fair Housing Act. So that's public and private housing providers. In terms of enforcement, enforcement will essentially be, this doesn't announce any new standards. The disparate impact standard, which the guidance is largely focused on, has applied for a long time. The Supreme Court upheld the disparate impact standard last year, but courts had been applying it for decades before that. But the guidance we issued it in order to inform housing providers how HUD will assess criminal screening policy should it receive a complaint alleging that that policy is discriminatory. And so enforcement in those situations will be the same as in any other case where we receive a complaint alleging discrimination. So the same administrative process will be followed. So HUD will investigate the allegations, and based on the evidence that it collects during that investigation, it will reach a determination whether or not there's reasonable cause to believe that a violation of the Fair Housing Act has occurred. And if we do find reasonable cause, HUD issues a charge of discrimination against the respondent housing provider, and from there the case will either be heard before an administrative law judge, or either the complainant or the respondent could choose to have the case go to federal district court.
Okay.
Did I answer all your questions there?
Yes, thank you. I have one more question probably for you, and I think this might be the last question of the day, depending on how succinct you are. There's been a lot of questions about the fair housing guidance. It mentions race and national origin as a basis for as protected classes that are impacted by the use of criminal records in housing. And there have been a lot of questions about whether whether there will be similar guidance released pertaining to people with disabilities, because a lot of people are noting that in their jurisdictions, sometimes when there's housing policies against people with records, it falls not only on people of color, but also people who have disabilities, particularly those who may have mental health issues. So I think that's probably directly for Jason.
Yeah, so I mean, you're right that the guidance largely focuses on racial and ethnic disparities in the criminal justice system. Obviously, we're aware that there is a pretty high rate of folks with mental illness in the criminal justice system, and the general principles in the guidance would apply regardless of the protected class implicated. So the disparate impact standard obviously applies the same regardless of if the allegation is one of race discrimination or national origin discrimination or sex discrimination or disability. But HUD is considering the possibility of in the future addressing disability-specific issues in this realm, but there are unique aspects there given that the Fair Housing Act does require reasonable accommodations. But at this time, HUD obviously has not issued guidance on that.
Okay. Well,
okay.
Thank you.
Marie,
ahead,
before you sign off, I would just like to say on behalf of HUD, we really appreciate this opportunity. Shriver Center came out with the report. We read the report. We were already doing some things in this area, but it really helped move us along. And the same thing with Vera. All that you do helps us push the envelope further. The fact that there are like 2,300 people registered for this webinar, we really appreciate that. We want to get the message out, and we do want to provide second chances. So I would just like to say thank you very much to everyone out there.
Thank you, Ron, for that. I think that's a good way to start to end this webinar. I think Amy said it before, and Principal Deputy Assistant Secretary Castro Ramirez said it before. This is sort of the beginning of a conversation and work around a lot of these issues, or at least the beginning on a very formal basis. I know a lot of people have been working very hard on these issues for a long time that are not on this call, speaking on this call, but that are listening in all parts of the country. So this work has been going on for a long time, and we're hoping that it'll just keep going further and further. Amanda, if you could go to the next slide. We have included resources. There's been a lot of questions about resources, so we'll try to make sure that we include, we address all the questions that are asking for policies or guidance or anything like that. We do list here the main HUD documents that have been referred to today. And then, Amanda, on the next slide, we reference the report from the Shriver Center. There was also a presentation that we made at HUD that's available online if you're interested in watching that. And finally, Vera has a fact sheet on public housing for people with criminal histories that might be helpful. And the next slide, please. Finally, we have a very diverse audience today, so this may not apply to everybody, but we did want to issue a save the date because we will have a second webinar on May 25th at 11 Pacific and 2 Eastern, and it's going to kind of do a little bit more of a deep dive into the guidance and discuss advocacy strategies for people who are trying to increase housing opportunities for people with records. So you are welcome to sign up for that, and I think we will probably send a link to that in our email to the registrants. And then the last slide is just if you would like further information. I posted Margaret and my information here. We are very much wanting to help people in this area, so you should feel free to contact us if you need help, if you're an advocate, or even if you're a housing authority. We have been helping some housing authorities on issues like this. And so again, I thank you very much for your time today, and I'm looking forward to all the changes that are going to come in this area. So I think Amanda will close off the webinar for us.
Yes, thank you, Marie Claire, and thanks to everyone who was on the call today for this great discussion, and for those of you who submitted questions. The Shriver Center would also like to thank the Butler Family Fund, Jim Mabey, and the John D. and Catherine T. MacArthur Foundation for their financial support of this work. I will remind you that within the next few days, you will receive a follow-up email that will include a link to a page where you will find a recording of today's webinar, a copy of the slides, and links to some additional resources, including those that were mentioned during today's webinar. And so to all of our presenters and to all of you in the audience, thank you again for joining us today.